gentlemen, it is indeed my privilege and pleasure to introduce you to my law partner, Jacob Maples. Jacob is from here. He grew up in the Arab area. I've known his family for years and years, and I was delighted back in, I think, 2009 when a resume sailed into the office where Jacob was looking to come back to North Alabama and practice law. I didn't really know Jacob very well, but I knew the family, and we interviewed and we offered him a job immediately. What I have come to find out is that Jacob spent his first few years, kind of like I did in insurance defense world. Jacob did more workers' comp work than anybody else in Birmingham. And he was in a specialty practice, and he learned more workers' comp than anybody I know. It is positively delightful to watch Jacob turn his knowledge of workers' comp to the advantage of the injured employee. What Jacob's going to talk to you about tonight is the ins and outs of workers' compensation.
Okay. Good evening. Now, Alan, I saw online that you inherited this program in 1990 because you didn't make your way to some seminar, and when you got back, they had nominated you to head up the People's Law School. Please tell me that's right.
I swear it's true.
Okay. And I make no comment then based on age or anything, but I can remember being about 12 years old and watching you on the People's Law School, and probably Jim too, and other people. And I must have just been a weird kid to be sitting around watching the People's Law School at 12 or 13 years old, but I think it sort of maybe planted a seed in terms of what I wanted to do with my career. I went to the University of Alabama and got my undergraduate degree, went on to get my law degree from the University of Alabama. And as Jim said, I was fortunate enough to come back home to Huntsville and find his firm, and it sort of took off from there. So I just want to say thank you to Alan and to the Alabama Association for Justice. This is such an important program, but I don't know if you really know what that group does beyond this. They are a group that lobbies on behalf of folks that are everyday blue-collar, hard-working people, and there's not a lot of friends in Montgomery for those type folks, and the Alabama Association for Justice is. And you know, we I think see most of the folks like Alan that volunteer time for that group. They're not getting paid to do it, and they're up against some folks in Montgomery that spend a lot of money to lobby for the other side of the equation, which is industry and insurance, and we're grateful for what they do. And I appreciate Alan and the other folks that are engaged in that fight every day. What we do at Richardson Maples is basically a wide range of personal injury type practice. Both Jim and I have that insurance defense background. I did workers' comp, he did auto claims for about 20 years, and we like to say Jim not only knows all the tricks of the trade, he created a lot of them for some of the big insurance companies. And so I've had the benefit of coming in with no real experience on the auto claim side, and then being able to be under his tutelage and sort of learn how to deal with those claims for folks that have been injured, not just in work injuries, but beyond that into to other sorts of claims. So we take great pride in that. It's a fun job. It is somewhat controlled chaos, like they've said, but I can assure you it's a lot more satisfying to go home and tell my wife that I have helped somebody get medical benefits that has not been able to get proper medical attention, and help somebody maybe in the context of an auto accident to get compensated for not just medical expenses, but lost wages and a lifetime of pain and other limitations that they may be encountering. And not to speak too ill of the insurance companies, which may seem like the theme here tonight, but when I went home from a day of doing insurance defense work, I didn't really ever have the sense that anybody appreciated it. And you know, met plenty of good folks on that side of the practice, but it's usually just another claim, just another risk, just another exposure for them to try to put to bed, put to rest for as little money as they could, without any real consideration of the human impact for the folks that you know frankly, I was defending claims against. So this is a totally different experience. It's why people like Alan Brinkley do what they do, and people like Jim and all the good firms in Huntsville that handle claims and represent the working folks of Alabama. And again, we are trial lawyers. That's sort of one of the things that probably interests some people here tonight is you think of that process and you see those television shows where, you know, there seems to be a lot of drama, and there is. But what we hope to do, and I think one of the goals of this program, is sort of take you behind the curtain, so to speak, and let you see not just the personalities of the lawyers that engage in that practice, but to know something about what it's like from the human side. And that's what I want to do tonight. This is the third time that I've been able to do this program, and I was scared to death the first time. I was a little bit younger than I am now and had not been out too long, but I was encouraged within, you know, a week or two of my program airing. I started getting calls from people that said, you know, you're talking about something that I'm living, and you know, I'm struggling to get medical care for a work injury. I'm struggling to pay bills on the workers' comp benefits that I'm receiving. And so what I understood is, like Alan said, this program reaches a lot of folks. And you know, the good folks in this room certainly hope you never encounter a situation where you need a lawyer, especially any sort of workers' comp claim, because they're very difficult to deal with. But all across Alabama, we've learned that there are a lot of folks that are hurting and need good advice and need help. And so we hopefully, through what we talk about in these programs, some folks can hear that, feel encouraged, and know that there are lawyers out there willing to help deal with difficult situations. So what I've given you guys in the room here are some materials to look at. I wanted to give you some inside workers' comp claims adjusting type materials. I've actually given you the basic claim handling manual that the Department of Labor hands out to new adjusters in this state. So that's about as inside as it gets, and it walks you through how to adjust a claim. And it's a good resource for you if you ever have a family member or loved one or yourself dealing with a work injury. It's something that you may want to look at to reference. It's certainly not exhaustive. It's somewhat limited, and they tell you on the first page that it's not intended to be a comprehensive outline of workers' comp issues, but it is a pretty good basis of information for you to draw on if you need it. And then I think the most significant thing that I want to do tonight in some of the other materials that we'll go through, we're actually going to show you some medical records of 3 different clients that we've represented. And all 3 of these folks were long-term employees. They went through a very, very difficult fight in their claims, and unfortunately that's what happens almost every time. Workers' compensation in Alabama is, you know, you can go to a docket call in any county in this state, and most of the cases there's an identifier for what type of litigation it is. So if there's a docket call where the judge gets all the lawyers together to figure out what's going on in cases and try to move cases, you'll see workers' comp cases show up maybe on as much as 20 or 25% of the dockets. They're heavily litigated. There are 20,000 or so work injuries in this state every year, and many of those end up in some sort of litigation. They all end up in a court approval process, because we do have a law in Alabama that requires any settlement of a workers' comp claim to be either approved by the Department of Labor or to be approved by a circuit court judge, and most cases go before a circuit court judge. So, you know, they're always heavily litigated, and there's always lots of disputes and things that we'll walk you through on not just the basics, but some actual claims, so you can kind of get a feel for what happens to folks who've been injured on the job. What I want to do before we get into those specific claims is just kind of give you sort of the black letter law, like maybe what you'd get if you were in law school. And honestly, if you were in law school, you would have been given some assignment to read this stuff, and then you'd have a professor walk around the room and put you on the spot and ask you certain questions about the materials. I won't do that, because it wouldn't be fair. You just got this material, but I hated that in law school, and you know, I think it's about as adversarial as you get in law school. You don't really learn the practice of law or learn how to engage in the practice of law until you're out and you get in court and see these things. But what we'll do is sort of give you the high points, the things you've got to know in terms of compensability, what makes a claim something that's covered under the Workers' Comp Act, what happens with the medical benefits, what happens with the lost wage benefits. And we'll go through those things and then move into these sort of case examples with these three different folks that we'll talk about. Just as a background as far as what workers' comp is, it was sort of born of the progressive movement of the early 20th century, and it's essentially an offshoot of what's called employers' liability laws. And believe it or not, in the 1800s, you couldn't sue your employer for anything. So even if they had engaged in some sort of activity that caused you to be injured or caused a relative to be killed, they were immune from liability. And with the Industrial Revolution and just the sheer number of folks who were injured on the job as a result of sort of that crude industrialization, we decided as a country, just from a moral standpoint, that we didn't want to create folks that were dependent on welfare because they had been disabled on the job. And so workers' compensation acts began to be sort of proliferated around the country, and Alabama passed their act in the 1920s. And not to Jim and Alan weren't there. I mean, that was before their time. I have no doubt they would have been involved in that in terms of advocating for this Workers' Comp Act, but that's certainly before everybody's time. But it was an important change in this Employers' Liability Act scheme because it ensured permanent medical benefits and lost wage benefits regardless of fault. And that's the trade-off in workers' compensation. You can no longer sue your employer in tort, which means you get damages for not only your medical benefits and your lost wages, but you get damages for pain and suffering, potentially punitive damages to punish an employer if they did something grossly negligent. But that was removed in favor of a system that covers generally everybody regardless of fault. And some people have a hard time stomaching that, and you know, we see the gamut of claims. We have some folks that come in, bless their heart, you know, they've done something really dumb, but fortunately for them, they are protected by this trade-off in this liability scheme of workers' comp. On the other end of the equation, we see folks whose employers are engaging in really dangerous activity and they've been injured, and they can't go out and sue their employer for anything other than workers' comp benefits. So that's the framework that we operate in when we deal with work injuries. The overall purpose of the Workers' Comp Act is to provide medical benefits and wage replacement for anybody that's been injured on the job as a result of a compensable accident. And it's pretty simple. You get hurt at work because of something arising out of the employment, you're covered. You get hurt at work for something, basically what we might call an idiopathic condition. If you come to work with some condition and it just happens to materialize at work and you have some sort of injury from that, you're generally not covered. And there are all sorts of examples. Horseplay and assaults, that's certainly not a compensable claim. Sir?
Sir, you're implying here that every employer has the insurance for their employees. Is there some sort of a cutoff as to which employers may not?
Sure. Yeah, and that's a broad question. Most people in this state are covered under the Workers' Compensation Act. But most people in this room may not have been, because you may have been an employee at one time or now of the federal government or of the state of Alabama. Those are not claims that I'm going to really focus on tonight. Those are covered under different compensation schemes that are similar to the Alabama Workers' Compensation Act, but not really the same.
What about a mom and pop operation with 1 or 2 employees? Not
covered. Not covered unless they choose to be. Generally, it's 5 employees that would trigger the coverage. But if you have seasonal employees and you generally would be there or just under that number, it's a good idea to elect in and have coverage. And to further answer your question, farm labor is not something that's covered under the Alabama Workers' Comp Act. There are specific exclusions for different sorts of labor, but they're a very small minority. And so what I'm going to focus on is generally the Alabama Workers' Compensation Act that covers most employment in Alabama. And it's not really close. It's the vast majority of folks that are out there working are covered under the Workers' Compensation Act. A big group of folks in this state that aren't are teachers. My wife is a school teacher, and we have short-term and long-term disability coverage for her because she's not covered by this workers' compensation system that requires mandatory insurance and provides wage loss and medical benefits. So you'll see a lot of teachers that go out and buy supplemental coverages so that they're not exposed to some sort of work injury that disables them, keeps them out of work or whatever. But that's a good question. You were a little bit ahead of where I was going, but I'm glad you asked that because it's something that we need to know about.
Rose from a fellow that I heard had beryllium. He'd been working beryllium in a back room, was not given safety devices, a mask or whatever. And then they fired him right after that because when he started filing claim.
Sure. And he's probably covered under, even if that employment is not subject to this workers' compensation coverage, those old Employers Liability Act statutes are still in place. And every once in a while we see one of those claims. In fact, we've got a case now that involves a really bad leg injury, and that employee was actually a farm laborer. And his employer had gone out and purchased some Employers Liability Act coverage. Now you go to your agent and ask for that coverage, they're going to be like, what are you talking about? That's very rare to see that. But it's still out there, and that's probably what your friend would be covered by if there were liability on the part of the employer. And that's the problem with the old scheme, is that you didn't have this no-fault compensation system. So in that framework, I think it's best to cover the act, understand that these other compensation schemes like the federal scheme, some state employees are covered under what's called the State Employees Compensation Fund. They're similar to the Workers' Compensation Act, they're just not the same. And trust me, we don't have time to cover all that, so we'll stick with the Workers' Comp Act of Alabama. And if you have one of those other claims, call me. Or if you have any kind of workers' comp claim, call us. We can help you. Now, as far as what I think you've got to know if you're an employee in this state, and you need to have some concept of what you're going to deal with if you get hurt on the job, I think the most significant area that we see disputes in or conflict in is with the medical care. In Alabama, under our act, the employer drives that entire process. They get to pick the initial treating physician. You have one bite at the apple to change the treating physician if you wish to do so through what's called a panel of 4 request, but the employer gets to pick the doctors that are on your panel. And so what happens is you have this sort of cottage industry in Alabama of physicians who are servicing the workers' compensation insurance companies. And it creates sort of this natural tension between doctors who are supposed to be serving the interest of their patients, and you would hope they would under their oath, and then they're also trying to serve their referral base, which are the insurance companies. It's something that you don't really see with private insurance because private insurance is generally accepted by any doctor. But there are only limited numbers of physicians who service workers' compensation insurers. So you have to understand when you get hurt on the job, you have no choice essentially in your medical care, and you have to treat with the doctors that the employer sets you up with. The first level of control that the employer has on a workers' comp claim is through what we call the work doc, the company doc, the doctor that is basically a primary care physician who serves only employers and workers' compensation insurance companies. The medical records that I've given you, most of those are from a company doc, a work doc. And there are some unique things in these records that you'll notice, and we almost always see, and they tend to show that maybe the injury isn't as bad as it actually is, and they tend to show that maybe the patient sometimes isn't as credible as they really are. So you see from day one, when the employee ends up at a company dock, there's already this sort of influence on the claim to get the claim resolved as quickly as possible. And unfortunately, that's generally somewhat counter to what the injured worker might need. The second thing that I think is critical to know, just in terms of the basics of workers' comp law, if you have an injury on the job, you have to give immediate notice. Basically, the law requires that you give notice within 5 days. There's an extension of that time frame for good cause. It's best to give notice immediately and to do it in writing. If you wait, you're just giving some claims adjuster somewhere an ammunition to say, well, you didn't really get hurt here, you were already hurt. Or, why didn't you tell us about it when it first happened? Did you get hurt after the fact? And so we tell folks, and usually that problem is long since been something that's developed if it is a problem, and we can't fix that. So you should give notice even if you think it's a minor injury. It's like Jim talked about with car wrecks. Sometimes you know that you've been hurt, but you don't know the extent of the injury, and even more so with workers' comp claims, you can't afford to wait to give notice. And you don't have another option to get medical care if you've been injured on the job. You've got one insurance company, and that's your workers' comp carrier. If you go and try to use your private health insurance, you may get in the door to your doctor, but once they catch wind of the fact that you've been injured on the job, guess who they come back to get their money from? Your policy with Blue Cross or Aetna or whoever says that they don't provide coverage for injuries that are covered by some sort of workers' comp policy. So if you've been hurt on the job, even if you think it's a minor claim, make sure you at least make that first step to go to the treating physician and let them control the process. You don't have a choice. You have to go through the workers' comp doctors. The third thing that I think is critical to keep in mind, and it goes along the lines with the authorization for medical through the employer, you have to cooperate in the treatment process. You have to, the law says you have to submit to the workers' comp doctor when they want you to go there. Sort of an oppressive scheme here, but they have the statutory right to control your medical care process. And so if you get crossways with a treating physician, that's going to create problems down the road. So you want to make sure you do exactly what they tell you to do. Make all the appointments. Don't skip any therapy sessions if you're going to physical therapy. Generally, and we see this on occasion because it's such a combative process, people will get into some sort of conflict with a treating physician, and sometimes that results in them being sort of kicked out of the doctor's office, and we can't fix that once that happens. So you want to cooperate as best you can within reason. And generally, if you do that, most of these doctors are willing to help you and provide you with the care that you need. And if they can't handle it at that primary care level, they'll refer you on to a specialist. Wage benefit or wage replacement benefit wise, the Workers' Comp Act is fairly straightforward. You get compensated at 2/3 your average weekly wage, subject to certain maximum and minimum rates. So if you make $1,000 a week on average, you're hurt on the job and you break your arm and you're out of work for a month, you're going to draw $666 a week until you're released to go back to work. If you make a lot more money than that, you're subject to the compensation caps that generally change every year. And I think in 2013 they upped the cap for temporary total disability, which is the benefit you get while you're out of work recuperating, to about $800. So even if you bring home $1,000 or more a week, and a lot of these government contracting folks around here make that kind of money, but they're shocked to see that their weekly check while they're out of work is substantially less than their wages. But that's sort of that trade-off that we talked about. There is a cap in Alabama that was set in 1985 on permanent disability benefits. Regardless of how much money you make, the most that you can draw for any permanent vocational disability or permanent physical disability is $220 a week. Now, I think one of the great sort of causes that folks like groups like the Alabama Association for Justice have is the unfairness of that cap. And I'll never forget, as a young lawyer doing workers' comp defense work, I was sent to the courthouse in Jefferson County to hand a check to a guy and do a settlement hearing. And I thought, this is a pretty good sized check. It was a $30,000 check. And I showed up, and the guy that greeted me had a nub at his elbow. And the most money that he could get based on this 220 cap was $30,000. He was a welder. He had gotten his arm caught in some sort of machine. He'd lost his arm, and he was capped out at a percentage of disability based on what we call a schedule. For the loss of an arm, you get 222 weeks in this state at a cap of $220 a week. And the way our laws are written, he didn't get any money for the impact that injury had on him in terms of his inability to make money going forward. He was disabled, and he qualified for Social Security disability. They provided him some limited benefit, but in terms of his workers' comp claim, he was capped at $220 a week for about 180 weeks of benefits. That was 8 or 9 years ago, and that cap is still in place. And just looking and preparing for tonight, I noticed that the legislature was kind enough to give themselves a pay raise after about 15 years of not doing so. But their capped rate and their weekly benefit is about 5 times what the injured worker is. So that's not fair. There are initiatives every so often to try to change that rate to sort of eliminate that inequity, but we just don't seem to ever have enough folks in Montgomery that want to up that rate. And basically, if you look at inflation, $220 in 1985 is about $600 or $700 now. So hopefully at some point we'll decide that that's an important enough issue and that we want to take care of folks injured on the job, and that we'll try to up that rate some. I mentioned the scheduled versus unscheduled, and that's something you need to know if you're injured on the job. If you have an injury to a particular scheduled member, which is generally just your extremities, you are capped at a certain number of weeks at $220 a week. And for the arm, it's 222 weeks. The entire loss of a leg is 200 weeks. So if you lose your leg on the job, you get 200 weeks of benefits at $220 a week, regardless of whether that keeps you from ever going back to work again. There are, as odd as it seems, they have scheduled member numbers for fingers and toes and all other body parts, but you're limited to the schedule if you have a scheduled member injury. You are not limited to the schedule if your injury is to your head, neck, or your spinal cord, your hips, or your shoulders. That's an unscheduled injury. That's an arbitrary distinction. You can be just as disabled for a permanent injury to your hand or arm as you can to your shoulder or hip, but for some reason we've decided that we don't want to make permanent total disability benefits to folks who have just scheduled member injuries. Basically the range of benefits for permanent injury is from whatever your schedule computes to be to, if you have an unscheduled member injury to your whole person, you could get up to 2/3 your average weekly wage for the rest of your life. And so generally most workers' comp claims don't encompass some sort of high-end permanent impairment or permanent vocational disability. But when they do, you certainly do need a lawyer to help you, because what we see happens is the insurance company comes to you after you've been out of work for a year or so, and they offer you some low-end settlement, and most people are just sort of forced to take what they offer. And oftentimes that includes a settlement that closes out medical benefits. And so, we tend to see folks come to our office when they get this letter in the mail, and the letter offers them $20,000 for an injury that's clear to us has at least impaired their ability to make money to a greater degree than what the offer is. So you want somebody to look that over for you and help you decide whether you need to accept it or go to court to try to obtain more money. Jim talked a little bit about what we call a third-party claim. Those are issues that you need a lawyer to look at, because if you're injured on the job and it's the fault of someone other than your employer, then you may have a claim outside of the Workers' Comp Act to recover from that third party. The most common area that happens in is in a car wreck. And you get injured on the job, you're entitled to workers' comp benefits, but you may also be entitled to make a claim against an insurance carrier for a third party. We have several cases of that nature, and that's always sort of a benefit to the injured worker, because their benefits are not necessarily capped, except to the extent of whatever coverage this third party may have. And that can be zero, like Jim told you, about 25% of the folks driving around don't have insurance. Most of the other folks that do generally have minimum limits of $25,000. The other sort of basic issue with a work injury is there is a retaliatory discharge provision in Alabama that says you cannot be fired solely for making a claim for workers' comp benefits. In other words, if you get hurt on the job, you report it, you make a claim, that can't be the sole basis for your employer terminating your employment. Those are really hard cases to prove. In Alabama, we're a right-to-work state, and so you can be terminated for any reason. But generally, when you're hurt on the job and you're fired shortly after giving notice, or if there's some pattern of discrimination that you begin to experience after you report a work injury, you can prove that sort of claim through what we call circumstantial evidence. You can go to court and try to convince a jury that you were fired for being injured on the job, and the benefits and the damages available for that sort of claim aren't capped, and they're not subject to any sort of the schedules or anything under the general workers' compensation laws. Well, let's talk about a couple of real-life examples of claims, unless anybody's got any questions before we kind of move on there. We might have time for a couple. Sure.
You were mentioning earlier about the shoulder injury, whatever, but 2/3 of the pay of your salary for the rest of your life. If you went ahead and is your pay reduced if you went ahead and got another job, or is that?
Sure, that's a good question. And for permanent total disability, let's say you had a really significant shoulder injury, all work in your past requires you to do heavy lifting, and that shoulder injury disqualifies you from that kind of work. You might be entitled to get permanent total disability. Okay. If you go back to work, they cut it off.
They do.
Yeah, and they should. I mean, you shouldn't be able to double dip, but most of the time when we have serious claims that involve some threat that the employer perceives, hey, we may go to court and lose, and this person gets $600 a week, we settle most of those claims for what we call a lump sum settlement. And that's where they kind of buy down the risk of the future payments with one check. There's a couple reasons why you want to do that as the employee, and that's because you may want to go back to work one day, and frankly, if you do, your benefits should be cut off. So a lump sum is something you don't give back. You take that money and you may go to school and be able to go back to work. The other reason why you want to do that is because if you are drawing a weekly workers' compensation check, your Social Security benefits are reduced or offset. And so we can avoid that offset generally by settling for a lump sum, and the Social Security Administration lets us put some language in the settlement paperwork that shows that lump sum is paid out over the life expectancy of the employee. And that generally reduces the offset. So 99% of the time, we settle workers' comp claims on a lump sum basis. But most of the time, a shoulder injury is not generally something that's going to prevent you from finding some sort of gainful and suitable employment. And the standard for permanent total disability is pretty high. You have to prove that you can't do anything you've done before. You can't be retrained to do anything else that's out there available for you on the open market. I would say probably less than 1% of the claims we see are true sort of permanent total disability claims. But They involve folks that don't have a lot of education, that don't have a lot of aptitude to go out and find other employment, and they've got a significant injury. Now,
Jacob, can I
Sure.
ask a question? Would you tell the people, you have a 40-year-old construction worker, and he has injured his back so bad he shall never work again. He's got 3 or 4 children. He can never work again. He is permanently and totally disabled. He cannot move. So tell him about what he would get per week the rest of his life.
sure. Well, here's the problem with that scenario. If you're in a county where you've got maybe a court that's a little bit more conservative, and keep in mind that these claims are all decided by one judge. There's no jury system with workers' comp. So you put your fate in the hands of whoever the circuit court judge is who draws your case. Unfortunately, the vast majority of those judges that we deal with are excellent. They're going to do what's fair. They're not beholden to one side or the other. But that employee that Alan's talking about, if you can't show that he's permanently and totally disabled, he gets $220 a week for 300 weeks. So that's $66,000, and that's it. If he can't go back to work, he's just sort of on welfare. Now, if you can show that he's permanently and totally disabled, he's generally going to get 2/3 of his average weekly wage until the day he dies, or until he's fortunate enough to find something he can do and he goes back to work, and then as a matter of law, those benefits are discontinued.
Also, be sure to mention, and I think you do it in your handout, the fact that if a woman loses her husband on the job, that she's entitled to 500 weeks.
Sure, there's
His
a,
pay, unless she remarries.
yeah, it's, now you wouldn't insinuate that anybody would do something to try to get those 500 weeks of benefit. I've never seen it, but no, and that's just, that's for any dependent, and he's talking about a death claim, and we unfortunately do deal with death claims with workers' comp. Those benefits are extended to a total of 500 weeks for the dependents. If there's more than one dependent, they draw the 2/3 of the average weekly wage for up to 500 weeks until that dependency ends. In other words, until a minor achieves the age of majority or until the spouse remarries. But I think generally the spouse remarries at week 501 is what we typically see. So, no, those are the most unfortunate of workers' comp claims that we see. I used to see a lot of those on the defense side, and you talk about a difficult time, sometimes trying to identify dependents, sometimes, trying to identify a lot of issues, but again, you have a limited compensation structure for even a widow who's been married for 30 or 40 years and her husband passes away. She gets half of his average weekly wage for 500 weeks, and that's it. Now, behind the claims manual that we've given you and I've put an exhibit tab on this at B. This is who we're going to talk about here as claimant A. And the good folks at home don't have the luxury of looking at these records, but I want you to notice, has anybody ever actually asked for their medical records and seen what shows up in your records as opposed to just in a discharge note that you get from the hospital? It's pretty amazing. I mean, you need to know this, not just in the context of workers' comp, but if you had an auto claim or any sort of claim where your medical records may be in evidence, there's a subjective or a history portion of your medical records, and everything you say to the doctor shows up in those notes. Sometimes we get them and they're incorrect, and you can tell they're incorrect, and we have to go to the doctors and say, hey, you need to change this. The injury wasn't in 2012, it was in 2013. That's sometimes difficult to do. So you want to make sure that you only tell the doctor what the doctor wants to know. It's amazing, we'll get these records and we'll see things in the history like, I got hurt on the job and I called my lawyer and, here we go. So claimant A is a 50-year-old male who fell 5 feet onto his backside and broke 3 lumbar vertebrae in his back. He went to the emergency room. He was x-rayed. X-rays don't generally show a compression fracture in your back very well. And you'll notice in this note that he was sent from the emergency room to the workers' comp doctor. Now, why you would need to do that, I've told you earlier, you're doing that to try to get some control over his claim and make sure that the care is directed to the doctors that the employer knows and trusts. He's in pain, he's got a lot of issues. But if you'll notice here, we see this almost every time in these occupational health doctors' records. It says at the bottom, they anticipate resolution of symptoms over the next 3 to 5 weeks without any permanent impairment. You're going to see on claimant B, who's a lady who had a herniated disc at 2 levels in her lumbar spine, her records say the same thing. So apparently every time you get injured and you go to these doctors, you're going to be fine in 3 or 5 weeks and you're not going to have any sort of impairment. But if you flip forward, you'll see this gentleman, he didn't get to go to a specialist within a couple days. He's right back at the company doctor on March the 9th. His injury was on March the 7th, and he's still in pain. Says he's having trouble with pain. He'd been at work. They sent him back to work with this broken back because it had not been properly diagnosed. But his long-term prognosis is still good. He's supposed to come back if he's having any further problems. And he does come back. He has to come back early. He comes back 4 days later, and he's still having problems with his back. He's hurting, he's getting worse, and then the guy's at work with a broken back. And we see this all the time. It's hard to stomach and rationalize that there are doctors who would not send folks to see a specialist when they're in the kind of pain this guy was in. His assessments, he's just got a back contusion. Go back to work, hope you get better. You look, and he's back 6 days later. And by this point, says he's back for a regularly scheduled appointment, but he's having pain and constipation. So his back condition is starting to get to a point where it's even affected his bowels. And it says, well, he's been taking his stool softener and fiber, he's okay. We see this over and over and over again. Now, ultimately, what happens is they get to a point where I think these doctors realize, well, it is pretty bad. I mean, we can't keep any further control over this claim. And if you look at the next note, which is from the good orthopedic doctors at SportsMed, a year later, we're talking about the fact that he had what's called a kyphoplasty in his lumbar spine at L1 and L2. That's where they go in and these discs have been shattered and reduced, and they have to pump this cement-like material into the disc to get it to regenerate and heal. This guy never regained full mobility. He never regained the pain-free status that he had before because he waited 6 months to get to this surgeon and have his back operated on and fixed. If you went in with Blue Cross or even Medicare, this would never happen to you. You would get that referral to a specialist probably from the ER, certainly from the occupational doctor. But this happens over and over and over again with workers' comp claimants. We were able to settle this gentleman's claim, and due to his, and this was a long-term employee. He'd been with these folks for 15 or 20 years, and there's no discrimination in how they treat the person who's been there 20 years versus how they treat the person that's been there, 2 months. Everybody goes to these initial level doctors, and if you get some sort of invasive treatment within 6 months, you're probably lucky. Now, I don't know if most people just give up, if most people decide to abandon the workers' comp process and go out and get medical care on their own, but that would seem to be maybe one of the purposes for why you get strung out and why there are delays and denials, and people like this gentleman suffer as a result. And we could have pulled from the records of literally dozens of people, but I found another lady that we had resolved a claim for. We'll call her claimant B, and her records start at what we've marked as C on this appendix. She's a home health aide. She'd been working for the same employer for 20 years. She's trying to support the weight of a hospice patient, and she herniates 2 discs in her back. Well, she goes to the company doctor on the same day of the injury, and of course, again, her prognosis is that she's going to be fine. There'll be no problems, no impairment within 3 to 5 weeks. That looks like the other guy. They always look like that. But then the next page shows you that, again, she ends up at Sports Med, and 7 months later, she's finally in there with a surgeon who has to go in and do a fusion of her lumbar spine from the L4 vertebrae all the way down to her sacrum at S1. That's, again, a sort of typical progression of these claims, as you might wait 4, 5, or 6 months to get the treatment that you really need. That would never happen with Blue Cross generally. Another couple things that are instructive from her case, if you look at the second page, there's an addendum to the note that the surgeon writes in here where he says that he had to discuss this case, and I've redacted the names, but he had to involve himself with what we call a peer reviewer. And there's a process in Alabama where the local doctor, who is a board-certified neurosurgeon, says this person needs a back fusion, and the workers' comp carrier sends the medical records to a nameless, faceless doctor somewhere in Florida, and that doctor says, nah, I don't think this person needs a fusion. They don't get it. This person was a doctor of osteopathy. Now, that's certainly not a board-certified neurosurgeon, but the workers' comp carrier refused to follow the directives of their doctor because they went and found some other doctor who said she didn't need the surgery. Fortunately, we had the case by then. We fought that, and we were able to get this lady the surgery that she needed. The other thing you notice from this note is that same peer-reviewing doctor, who had never met our client, didn't know anything about her, he apparently wanted to talk to her surgeon about whether she was interested in something called secondary gain, and whether she needed some sort of psychiatric evaluation to make sure that she wasn't in this just to get some money through workers' comp. I mean, that's sort of par for the course with workers' comp. You see this in a lot of records. There's a lot of folks out there that just don't know any better, and they think, well, I've got to go through this. But we were able to get involved again and help this lady get the surgery that she needed for her back. And like I said earlier, just like claimant A, she had been with this employer for years and years and years. And for the employer, they didn't really have any say in how this process went. They had bought workers' comp coverage from a big insurance company that you've all heard of, and they turned the entire process of dealing with this employee's claim over to them and just sat back and really had no say in what happened to her. And that's usually how it goes. There are some employers that are self-insured and they get to call the shots, but most are not. And most of these big insurance companies have a team of claims adjusters and managers and folks that do nothing but pore over medical records in an effort to try to find any reason they can not to provide medical care for an injured worker. Now, the last person I want to talk about, we'll just call him C. Again, somebody who had been with his employer for, I think, 15 years when he got hurt. He was a police officer in a small town in northwest Alabama. And I've given you, at what I've labeled D here, the Alabama Administrative Code on what a medical case manager is supposed to do. Unique to workers' comp claims in Alabama are nurse case managers. They're folks that show up, shake hands with the employee and say, I'm so-and-so, I'm here to be your nurse on this claim. And most folks think, oh, wow, they really like me. They really care about me. They've sent some nurse out here to help me get the medical care I need. Well, what those folks generally are the eyes and ears of the insurance claims adjusters, and they are not your friend. And the second page shows really what these folks are generally up to. And the story on how we got this handwritten note that I've marked as E, it's the very last page in your materials. I learned doing defense work that you could find some interesting stuff in the files of the nurse case managers if you send them a subpoena. And they usually freak out over that, man. They don't want you to see what's in their records. And so we sent this nice lady a subpoena, and she coughed up her whole file, which is kind of odd. Sometimes they go hire a lawyer and they just get all sorts of flabbergasted when we want to see their records on our clients, which is kind of odd. But this turned up in the file. And this is her handwritten notes when she walked into the appointment with our client's surgeon, he was having serious cervical issues from a fall, and outside of our client's presence, she talked to the doctor and handed him these notes, which would be fine if they were in any way accurate. But here's what she told the doctor in these notes. She said that this gentleman was about to be fired or asked to resign when his injury occurred. That was not true. She suspected substance abuse. She didn't know the guy. She had just met him at that appointment, but apparently felt like, she needed to tell his doctor that there was some substance abuse going on there. His wife had left him. The guy wasn't married. He had not tried to find any means of gainful employment. Well, he had a herniated disc in his neck, and he was a street officer. You don't want that guy out there serving and protecting. So no, he had not gone back to work for about 3 months when he finally saw the surgeon. She said that he was taking multiple pain meds from, and I've redacted the doctor there, but that was his family doctor that he had gone to get some medication for his his neck problems, and that all he had told her was that he wanted pain management, and that's sort of that's the buzzword. In fact, this lady, this nurse case manager, she hit all the buzzwords for how to smear the character of an injured worker to his treating physician. He was about to be fired, so this claim was really just about getting back at his employer. He was engaged in substance abuse. He was just in it for pills. He wasn't trying to work, and he just wanted to get to somebody who could give him those pills. And so, guess what happens? The doctor, we see this over and over. Sometimes these doctors are so busy, they're relying on these nurse case managers to give them accurate information. He saw our client one time and said, "I can't do anything for you." And so we had to get involved there and try our best to get him to another doctor. We had to go through basically just private pay for him to come out of his pocket to get somebody to assess his injuries and provide medical care. Believe it or not, this is going on every day in this state. And it's really a reason that we come to work, is to try to help folks deal with this nightmare. We went and deposed this doctor, and with a straight face, he looked at me and said he relied on all this to form some of his opinions about my client. He didn't ask my client about any of these things. He didn't ask him if he had been fired or was going to be fired, or if he was looking for, substance abuse. He took this lady's word for it, and he just let the guy go. And we find that that's more often the case than not with some doctors that we're kind of shocked to see that with. Now, there are other clinics that aren't necessarily as beholden to the work comp companies, and we try our best to get folks to those doctors, but this is going on every day, and it's going on because in Alabama, like a lot of other areas of our law, we've created these mechanisms that benefit insurance companies and big business at the expense of, really, I think, our morality. And, I kind of close and then ask for some questions with this, but, in a state where, and I'm a Christian, so I value the Ten Commandments, and being able to trot those out and rely on those as sort of the backbone for our laws and what we expect of each other. But when we focus on the outward things, look at us, look at these, marks of how good we are at the expense of what we're really doing to people, you got to wonder, where are we? And so, if you know folks who have been hurt on the job, we're glad to talk to them, glad to help. We really take it on as a cause. Lawyers get 15% by statute of the recovery that you help people get for work injuries. Most of the time, that's not a lot of money. And, we don't take workers' comp cases because, we necessarily pay our employees' salaries with those. We take those because we really do feel like we can make a difference, and people need help. I'll kind of stop here. I may have a few other things to cover, but are there any questions, ma'am?
I have a good friend whose husband was hurt on the job. The person did not have any kind of workman's compensation. The person work sometimes isn't able to work, sometimes hasn't held lumbar
Mhm.
issue, has been in hospital several times. Is there any recourse for this person?
Well, if their employer was required to have that coverage and didn't have it, there's a penalty where you can obtain double compensation. Now, what happens invariably if there's supposed to be coverage and there's not, it's a nightmare to try to get any benefits. You know, we had a case when I was on the defense side where a fairly large outfit had gone to an agent and the agent stole their money and never placed their coverage. And then the agent was arrested and had no assets. And so we had to just, you know, scramble to get some money together from the employer to try to deal with the medical issues of the injured person. And there's, you know, there is a what they call a guarantee fund where this happens, and you know, folks can go to that fund to try to obtain compensation. It's not, it's sort of like state employees who are injured on the job. There's very limited benefits through that guarantee fund. But it is something that they could maybe contact those folks down in Montgomery to see if there's any way, at least for them to get their medical benefits paid. And I think the guarantee fund is sort of it's a backup. It's kind of somewhat of a welfare system, but it may be available to your friend. Sir?
We're out of time.
All right.
But thank you so much.
Thank you.
Good job, Jason.
Thank you.
So much.